Okay, well, good morning and welcome to our panel on legal considerations related to the entrenchment of property rights. I'm going to speak first concerning possible routes to a constitutional amendment, focusing in particular on the Reid-Hillier idea of using the bilateral amending formula. Then my two research assistants from the University of Saskatchewan are going to speak. Laurel Benyon is a second-year law student who previously completed a geology degree at McGill and worked in mining exploration prior to law school. And she has a wide array of interests, works as a volunteer in our law school's poverty law clinic, and has a forthcoming co-authored article in the Boston University International Law Journal on issues of Arctic energy development and Indigenous peoples. She'll be speaking on the different legal effects of different texts for a property rights clause. She was, of course, co-author on the paper that I was speaking to yesterday, and this is drawing on different parts of that and also some other considerations. Michelle Lange is a third-year law student starting work in a few months as an articling student at the law firm of Kanuka Thuringer in Regina. Her prior studies were at the University of Saskatchewan's Edwards School of Business. She serves as an executive member of the youth wing of the Saskatchewan Party, and she's been a champion mooter within the Jessup International Law Moot Court competition. And she'll be speaking about a paper that we're currently co-authoring on lessons from selected comparative and international law for ways that a property rights clause might be judicially interpreted in unexpected ways, and lessons for how to constrain those interpretations. Now, having said what you have to look forward to, I need to somehow pull you back to being interested in my presentation. Canadians aren't always thinking about all the details of constitutional amending formulae, even though the quest for a Canadian-based formula was at the root of the 14 rounds of constitutional negotiation leading up to 1982. But having spoken yesterday on how property rights got left out of the Charter, I want to speak today to how they can get into the Charter. I'm going to focus especially on the main groundbreaking proposal, in my view, put forward by Scott Reid and Randy Hillier, which is the possible use of the bilateral amending formula. I published an article on the topic at the start of this year in Constitutional Forum, and that's available online if you want to read about this in more detail. So I'm going to try today just to set out several briefer points related to the possibilities for that route, to put the argument for why it can work, in my view, in legal terms, and to identify one possible further possibility under it, which I hope is a little bit creative, and we'll see what people think of the idea. Just to give context, the media more often discuss the so-called 750 formula or the unanimity formula. And the grand constitutional packages that were under discussion through the 80s and early 90s would have required the use of these formulae. So the one involves the federal government and 7 provinces with at least 50% of the population. The other requires unanimous support from the federal government and all 10 provinces. And those apply to certain types of full-scale constitutional changes. At the time of the Charlottetown Accord, some provinces adopted legislation that requires referenda on future constitutional changes. And of course, there were referenda held simultaneously across the country at the time of the Charlottetown Accord, after some provinces had enacted this as a requirement. And in 1996, the federal government, in the context of various strategies around a future secession referendum, adopted complicated legislation trying to create a sort of regional veto on future constitutional amendments. So what do these add up to? They add up to simply that constitutional amendment has become very constrained in terms of thinking about it at a full-scale level. But there are routes to constitutional amendments apart from the 750 formula or the unanimity formula. And that's what Scott Reid and Randy Hillier have identified. So one of those other routes that I'll mention just briefly is Section 45. So today's a little bit more legally detailed than yesterday. Under Section 45, there's a provision under which the legislature of each province may exclusively make laws amending the constitution of the province. And we don't usually talk a lot about provincial constitutions, but in principle there is a constitution for each province in Canada, apart from the Canadian Constitution. I believe that only British Columbia has a written provincial constitutional text, but others could develop such texts, and property rights could conceivably be entrenched there in a manner that took priority over other provincial legislation. So based on Section 45. However, such a constitution would remain subject to future amendment by that legislature, the same legislature acting alone. So it's not a strong form of entrenchment if a future set of legislators change their mind about...
Sorry. Dan, can you turn the sound up just a little bit? Some people in the background.
Yeah, absolutely.
Okay, well, we're only getting to the exciting stuff now, so I'm just as happy they didn't hear the first part. So, the first possibility is that provincial constitution, in which there can be an amendment, but it can be changed by the provincial legislature acting alone at a future date. It still may be symbolically significant, much like balanced budget legislation or something else of that sort, but it's subject to future change. A second route that moves beyond the province acting alone is Section 43, the so-called bilateral amending formula. It allows a constitutional amendment to the Constitution of Canada, and here I'm going to quote a little bit of text, in relation to any provision that applies to one or more, but not all provinces. And it allows that, so that's end of quote, that allows it to be made by just the affected province or provinces and the federal government. So that route is actually, we can get into bigger details. It's exempted within the 1996 federal legislation on regional vetoes. And I won't get into the relation to the referendum legislation. We can go back to that if that's of interest. But the point is then that federal legislation doesn't interfere. You don't need the 750 formula. You don't need the unanimity formula. You can make an amendment for just one province or just some provinces with those provinces and the federal government. So it might strike you as some kind of obscure provision that Scott Reed and Randy Hillier found, and they're very creative to have found it. I give them full credit for that. But it's not as obscure as it first sounds because it's actually been used on a number of occasions. In fact, it's been the main route to constitutional amendments since 1982. In Newfoundland, it's been used 4 times, 3 times to modify denominational school rights, and 1 to change the name of the province to Newfoundland and Labrador. It was used in Quebec to modify, well, actually to end denominational school rights. It was used in Prince Edward Island to modify old constitutional text that required the maintenance of a ferry to the island and to allow a bridge instead of a ferry. And in New Brunswick, and this is really interesting, it was used to add a whole new section to the Canadian Charter of Rights and Freedoms, Section 16.1, which now guarantees certain linguistic rights differently in New Brunswick than elsewhere in the country. The other thing that I'll point to is that some of these amendments have actually been the subject of legal challenges, with the effect that there's actually a body of judicial precedent on the use of the Section 43 bilateral amending formula, which gives even a little bit of additional security on the principles concerning its use. The changes to denominational school rights in Newfoundland and in Quebec both went to appellate courts, and in both cases the Supreme Court of Canada denied leave to appeal from the decisions from those appellate courts. And those courts accepted the possibility that Section 43 could be used even in a way that modified rights of a linguistic minority or group, or a religious minority group, rather. I guess what this says is there's actually a body of jurisprudence that supports the idea that Section 43 can be used for a rights amendment. Add on to that that there seem to have been no objections to the use of Section 6, or to the addition of Section 16.1 in New Brunswick, the addition of a section to the Charter based on the use of the bilateral amending formula. So there's past practice supporting the view that Section 43 can be used to add a province-specific section to the Charter, even when relating to fundamental rights. And the fact that we're talking about an individual right in relation to property should arguably make it even more appropriate than in the instance of a complicated group consideration, as with the linguistic rights in Section 16.1. The hope with constitutional entrenchment, and this is sort of my closing point, although I have a couple of quick things to say, is of course to get something relatively secure that won't be immediately changed by government that suddenly finds it inconvenient later. One possible question to raise about the use of the bilateral amending formula relates to whether the clause could simply be removed later by a future provincial government acting in conjunction with the federal government. One thing that tells against this is that if it's entrenched in the charter, it becomes politically delicate for someone who later proposes to remove what's been identified as a fundamental right. But legally, it would remain possible. And that's where I'm going to offer one other tentative legal idea. But the question of its political feasibility, I'm going to have to leave to others to judge, and I'd be interested if there's reaction in the question period. Calling Section 43 the bilateral amending formula is technically a misnomer, because it can be used for an amendment that affects more than one province, just not one that affects all the provinces. And in that case, it requires the support of those provinces affected and the federal government, or the federal parliament. Were more than one province to enter into a sort of property rights zone with the right sort of structure, it strikes me as at least possible that there could be an entrenchment by Section 43 that would involve a commitment at the same time by several provinces that would require several provinces with the federal government both for the entrenchment and for any later change to move back from the entrenchment. And I offer that legal idea tentatively, with some thought into it, but without precedent for it, as with the standard bilateral amendment, and with the possibility that that may politically not be as feasible, but I'll put the idea out there. But my main point is simply to say that the amendment as proposed by Scott Reed and Randy Hillier would very much so seem to be legally possible under the bilateral amending formula. They've cast a relatively narrow text in terms of a right not to be deprived of the title, use, or enjoyment of real property, or of any right attached to real property, or of any improvement made to or upon real property, unless made whole by means of full, just, and timely financial compensation, all referring to real property. That may escape some worries about the effects of different texts, but it also offers protection only in the context of real property. Some people here want to talk, obviously, about other kinds of property as well. In the next two presentations, we're going to hear some discussion of further considerations related to possible legal texts for a property rights clause.
Good morning, everyone. I'm Lorella Binion. I'm one of Dwight's research assistants. First of all, I'd like to thank the organizers of the conference for allowing me to present among this very high caliber level of speakers. It's a really incredible, if not intimidating, opportunity. This summer, while I was working for Dwight, one of my projects was a co-authored paper on the history of property rights in the Charter, which I think a number of you saw Dwight present yesterday. My main contribution to the paper was researching the precise history of the constitutional debates to determine why property rights did not make it into the Charter when, as many of you know, they were included in Canada's previous rights instrument, the Bill of Rights. This mainly involved reading transcripts of the Special Joint Committee on the Constitution, which is the committee that was set up to debate the content of the Charter. I'm not sure if this sounds as tedious to you as it did to me when I first started this, but it turned out it was actually a really interesting exercise. I fully expected, being a law student with no experience in politics, that to find lots of logical and reasoned arguments debating the merits of one clause over another. But instead, to my surprise, the debate turned out to be quite partisan, with property rights in particular, because that's what I was looking at. And I thought the parties seemed to be arguing almost in abstract over the general idea of property rights, and barely at all over what property rights would mean legally. One thing that furthered this impression was that property rights were proposed in 4 different clauses over the course of negotiations, each with different legal implications as to what would be protected and what would be left to government. I would like to introduce to you the 4 provisions and make a brief speculation as how each of them might have been interpreted had they made it into the Charter. My ultimate goal is to demonstrate how the position in the Charter and the wording of the provision can affect the legal meaning of a clause in the Charter, and second, suggest that maybe the general confusion around what people meant to protect in the property rights clause contributed to its ultimate exclusion. I will note quickly that the Charter is interpreted holistically, with each provision interpreted in light of other provisions. So had one of these property rights clauses made into the Charter, it could have possibly affected the entire document. A specific example of how the exclusion of property rights has affected interpretation of other provisions can be found in the case of Irwin Toy Limited in Quebec, where the court found that the deliberate exclusion of property rights from Section 7 meant that economic rights as generally encompassed by the term property are not within the perimeters of the Section 7 guarantee. I'll now introduce the 4 provisions. Property rights were proposed in the Section 2 fundamental freedoms, the Section 6 mobility rights, the Section 7 legal rights, and as its own standalone property clause. I'll begin with Section 2. The Section 2 fundamental freedoms includes freedom from religion, expression, assembly, and association. The Section 2 amendment would have added a fifth subsection, Section 2E, which read, freedom from unreasonable interference with privacy, family, home, correspondence, and enjoyment of property. It's difficult to predict exactly the level of protection that this clause would have afforded property rights because, on the one hand, the fundamental freedoms are not subject to strong internal limitations. The bulk of the analysis is done at the Section 1 stage when the court must decide if a limitation is justifiable in a free and democratic society. On the other hand, Section 2E has built-in limitations, the first being the words unreasonable interference and the second being the term enjoyment of property. In this case, it would be up to the courts to define what unreasonable means and also to decide what enjoyment means. At what point am I no longer enjoying my property? At what level of infringement do we reach this point? Without speculating on the lines that the court would draw in those circumstances, I think it's safe to say that the limitations written into Section 2E would cancel out any elevated protection it would have received by virtue of being a fundamental freedom. The next provision I would like to address is the Section 6 Mobility Rights Clause, which was at the time Section 8. Section 8 sub 2 read, every citizen of Canada and every person who has been lawfully admitted to Canada for permanent residence and has not lost the status of a permanent resident has the right to acquire and hold property in and to pursue the gaining of livelihood in any province or territory. While this clause protects an individual's right to acquire property anywhere in the country, it doesn't protect any rights after property has been acquired, which leaves open the entire area of expropriation. In the interest of time, I'll move on to the Section 7 legal rights, which was the most popular clause for the inclusion of property rights. This section would have read, everyone has a right to life, liberty, security of the person, and enjoyment of property, and the right not to be deprived thereof except in accordance with the principles of natural justice. The two differences in this version of Section 7 and the version that was actually adopted was, of course, the addition of enjoyment of property, but also the change in the words natural justice to fundamental justice. One commonly cited argument for not protecting property rights is a fear of Lochner-style judicial activism stemming from an interpretation of due process as substantive rather than procedural. In Canada, there is well-developed jurisprudence defining natural justice as procedural due process, and so had property rights been entrenched in this form, likely this fear would not have been actualized. However, since it was adopted using the word fundamental justice, since then, the courts have interpreted this to mean substantive due process rather than procedural, so if property rights were to be amended into Section 7 now, it's possible that this would afford the court the type of powers that people were hesitant to give them. Finally, property rights were proposed within their own section of the Charter, which was at the time Section 9, composed of 3 parts. Section 9 sub 1 read, everyone has the right to the use and enjoyment of property individually or in association with others, and the right not to be deprived thereof except in accordance with law and for reasonable compensation. 9 sub 2 was, nothing in this section precludes the enactment of or renders invalid laws controlling or restricting the use of property in the public interest or securing against property the payment of taxes or duties or other levies or penalties. And then Section 9 sub 3 is a limitation clause very similar to the Section 1 limitation clause in the Charter right now. Subsection 1 specifies that a person should not be deprived of the enjoyment of property except in accordance with law or for reasonable compensation. The phrase in accordance with law is not found anywhere else in the Charter, and for good reason, because all it means is that if a government wants to infringe on this right, they must do so in a way that's not illegal. And since the government has the power to enact laws, they can get around this pretty easily. Subsection 2 addresses some of the principal worries of the provinces at the time of Charter negotiations, namely that property rights protection would limit the government's ability to interfere with property for effective governments. I know that a lot of people's view here is that property rights should protect against government interference, full stop. But the way this clause addresses property rights is to say that the government has the power to do what it will with people's property so long as the individual is adequately compensated for any loss that the government action has caused. Looking at the history of these practical realities of why property was excluded from the Charter, what I see as a contributing factor to, first of all, the lack of debate on property rights during Charter negotiations, but ultimately the exclusion of property rights, is a general lack of clarity and consistency in the provisions as to what the drafters meant to protect by the term property rights. In moving forward on the goal of entrenching property rights in the Charter, I think there is value in developing a clear and pragmatic property rights clause that would be acceptable to the majority of voters. And this, I think, would hopefully help shift the property rights debate to how property rights should be protected instead of whether property rights should be protected.
Good morning, everyone. My name is Michelle Lange, and I too would like to say thank you for inviting us to speak at this conference. I've had a wonderful weekend, and it's really nice to be able to hear such other talented speakers and to get to know other people who actually agree with us. That's a nice change. What I would like to do today is to discuss a case which has interpreted a property rights section and how this could be relevant and what lessons we can take away when possibly drafting a clause like this in Canada. The case I will be looking at and I will be discussing is from the Inter-American Court of Human Rights, the case of the Awas-Tigny versus Nicaragua. Now, before I begin to talk about this case, Canada is not a party to the Inter-American Court of Human Rights, nor is Canada a signatory party to the American Convention on Human Rights, which is being discussed here. However, the language that is found in Article 21, which is the clause that protects property rights, is very similar to some of the wording that Laurel had mentioned, which had been proposed in Canada's original charter. So it's therefore useful to look at how a particular court has interpreted what this clause has meant, and as you will see, what it can be stretched to possibly mean that may not be intended. The facts of the case involve the Awas-Tigny, who are an indigenous group in Nicaragua and have a particular history of practicing communal property rights. What this means is they believe that land can neither be bought nor sold. It can be transferred from family to family. However, they divide their land in ways where particular land is used to live and inhabit, but most of the land is used in a communal way for agricultural activities, fishing activities, hunting activities. So as we can see, this is a bit incompatible with how we would view the use of property in, for example, Western jurisprudence. What had happened was Nicaragua had granted a concession of land, which they viewed to be a state land, to a logging corporation. And the Awas-Tigny brought a claim to the Inter-American Court of Human Rights, claiming that first, this was their land, and second, Nicaragua should give their land back to them so they can practice these forms of communal property rights. The Inter-American Court of Human Rights ruled in favor of the Awas-Tigny, citing, among others, violations of Articles 1, 2, 21, and 25 of the American Convention on Human Rights. The relevant case, or the relevant clause today, as I said, is Article 21. And the relevant wording of that clause is, everyone has the right to the use and enjoyment of his property. The law may subordinate such use and enjoyment to the interests of society. So as I mentioned, and as Laurel mentioned, this is very similar wording to what may have been introduced in Canada. What is interesting, though, is the approach that the court took. It is well settled academically that the interpretation of the court was including revolutionary, far-reaching, and unprecedented. And as we are apt to know, the courts tend to interpret things how they so choose, and this has happened in Canada before. So looking at the four major reasons the court gave for this interpretation, and therefore four lessons we can take away when considering what kind of clause to draft in Canada. As we heard yesterday from Mr. Stockwell-Day, language matters, and language is important. And therefore, it is very important to consider exactly what we would wish to protect and how we wish to protect this. Firstly, the court stated that in human rights treaties, as this treaty was, they should be given a universal and autonomous reading. So different than how the Charter is read, as Laurel pointed out. However, this was their justification that they were used to say that they can read this clause in a manner relevant to the current living conditions, or as we would know, something like a living tree interpretation. And importantly, though, the court made notice that in the drafting history of Article 21, the wording was changed from everyone has the right to use private property, the wording was changed to the use and enjoyment of property. The court made specific note and said that because the word private was specifically taken out, Therefore, they interpreted property rights to include such things as communal indigenous property rights. Now, the lesson to take away from this for drafting is to ensure a very clear drafting history, so when the court would look at why, for example, is this clause being drafted and what is the point, they can look and say what the intent of the framers was. And if this is our goal here, it would be to protect private property rights, and therefore make no question as to what the point of this clause was, and the court cannot take their creative interpretations of it. As we can see, a small word made an enormous difference in the outcome of this case, and therefore it is worthwhile to ensure that the clear intent of the drafters is made known. Secondly, the court looked extensively into the traditions and practice of this particular Indigenous community and noted particularly their spiritual and cultural connection to the land. And it was because this land was deemed to be integral to not only their survival, but also to their religious and cultural well-being. It was therefore important to protect not only their claim to this land, but their right to use this land in a way that is not necessarily compatible with how we would interpret it. Therefore, the lesson to take away from that is a clause should exclude matters particularly pertaining to religious or spiritual connections, as to avoid bringing up any specific Aboriginal issues. Now, Aboriginal issues and Aboriginal rights are protected specifically under various other protections of the Charter. Therefore, it would be worthwhile making specific reference to what exactly is meant to be protected here. And in this case, it would be individual property rights, and not necessarily in a way that is in relation to a spiritual, religious, or cultural connection to that land. Thirdly, the court stated that because of the nature of human rights treaties, they weren't necessarily limited to looking at any specific domestic statute. Nicaragua's own state laws, both in their constitution and in different domestic laws they passed, recognized the right of Aboriginal groups and Indigenous groups to the use and enjoyment of communal property rights. Therefore, they were able not only to use an interpretation from an autonomous point of view, but also being able to look at Nicaragua's own laws to justify this interpretation. The lesson to take away from this is therefore to be aware of any conflicts between possible constitutional clauses and existing statutory rules on property. The general lesson being to be specific and to be able to be clear on exactly what is meant to be produced by this charter or by this clause, and what exactly is trying to be protected. Now in Canada, as we all know, we are very aware of Aboriginal practices and Aboriginal culture. However, this doesn't mean that we can't make something that would necessarily be very specific to what is trying to be established and accomplished here today. Lastly, one of the justifications the court made is they outlined the obligations of a state party pursuant to Article 1 Sub 1 of the American Convention on Human Rights and Freedoms to respect the rights and freedoms guaranteed to these individuals, essentially actually forcing states to oblige and to follow these rules. Now, the reason why they said this is because Nicaragua had previously committed to demarcating and delineating various Aboriginal lands, and the court ruled that this program was illusionary and ineffective, and therefore, by not giving the Awastigni and other Indigenous groups their actual lands back, this was deemed to be an actual human rights violation. Now, the lesson to take away from this is to properly define to what extent the act of a state may or may not incidentally affect the sought-after rights. Now, as we've heard from this conference this weekend, property rights are a vague concept in itself, and as we also heard, language is what will be used to define exactly what property rights are, what private property rights are, what the state can't do, and what the state cannot do. But what this means is because this is such a far-reaching concept, it would be worthwhile to be aware of what acts of the state may affect this, and what either existing laws or future laws may have an effect on this. And although regulatory regimes are very complex, it is valuable to be aware of the scope of such rights and what effect these various state undertakings may have. Now, generally, I'd like to conclude by, as I've said, looking at the interpretation between necessarily whether we believe and whether the courts believe our charter is a living tree or whether we should stick to the framers' intent. Now, I think what many of us believe here, and I would like to think that we can stick to what we intend to have here. However, this is yet another case of the court taking a creative and evolutionary, in their own word, approach to interpreting this type of clause. Therefore, it is of the utmost importance that any provision be clearly worded to avoid any broad or varying or creative interpretation here. As I've said, the concept of property rights itself is described as a bundle of rights. And if that's a bad concept in itself, trying to wrap our minds around what exactly therefore private property rights are is even more difficult, let alone telling this and selling this idea to the public that this is something that they should be interested in and this is something that is for their own well-being. Language matters, and it is language that will give rise to these rights, and this is why we should give these considerations today. Thank you.
Hi, I have a question for the panel. Maybe this has been too much of a hypothetical, but in your opinion, given the way all these different proposals have been worded, would the adoption of one of these proposals lead to making Aboriginal property rights claims, or individual property rights on Aboriginal reserves impossible?
This is the last one where they're allowed to defer to me. But I guess one would need to look at each proposal very specifically as to if any of them would make private property rights on Aboriginal reserves impossible. It doesn't strike me that any of them are likely to do that. But one of the real complexities in the Canadian context on any property rights clause is how that property rights clause is going to interact with Aboriginal property. And I guess I'm not sure, but what there might even be arguments that some communities might try to put that private property on reserve is in tension with Section 35 rights of some sort. And so it's very unpredictable where the legalities would lie, I think, in terms of is there something that could interfere with private property on reserve out of one of these clauses. So I'm saying I don't know, but it's an important thing to think about. And the interaction of any property rights clause with Aboriginal property is a very key consideration.
The question I have, folks, the panel is on the other side of the aisle. We have discussion in the last couple of days about property rights and ultimately whether or not an individual's right can slow down the Crown. I would ask the public interest definition on the other side of the aisle is whether or not there's good language around the definition of the public interest, the Crown and the Crown's ability to steal through its corporation or not, and whether or not that ambiguity further complexes this idea of what property rights mean, how do we define that versus the definition of the public interest.
Well, I think what's important with the public interest, as you said, is even I think going into this conference, what we all thought what property rights included, I'm sure it changed as we saw the speakers, and therefore my advice would necessarily be, whatever merit this has, is that especially when talking about what the public interest actually is, you have to define what that is first, and therefore what relation property rights to actually have. And I'm sure when many people hear property rights, they only think of real property in their land, but therefore what that can also mean with their actual possessions, their actual chattels. And what I think then is, especially as we've seen some of the wording of the language, to actually keep it as specific and as clear as possible without necessarily being exclusionary and being too specific to be read so narrowly that the court can, for example, continue its interpretation to say it doesn't protect economic property rights.
Appreciate the discussion of clear drafting, which is obviously important. It's instructive, actually, if you compare the amending formula in the American Constitution, which I think is under 200 words in one clause, with the Canadian Constitution, which is over 1,100 words scattered across more than half a dozen clauses that refer back and forth to one another, often in ways that seem contradictory. You can see the virtue of it. But I want to throw out as an idea, what will constrain courts from getting jiggy with the text is not precision in drafting. They can get around that by creatively applying the doctrine of substantive due process. It's checks and balances. We live under a system of checks and balances theoretically here, so do the Americans. Legislature checks the executive, courts check both, but someone's meant to check the courts as well. All three branches are meant to be checked, and I think that's something we pay insufficient attention to. How do we discipline the courts if they don't do what they're meant to do constitutionally? Which branch steps in and how? Because if nobody does, give men no power that you are not contented that they shall use.
I guess I'd say on that obviously there are certain checks and balances in the Canadian Constitution in terms of the possible use of the notwithstanding clause in certain instances, but it's been politically very difficult for that to function in the way that it could have. I guess the other big check on the courts of a sort, or the other influence on the courts, is to try to ensure always that there's a discussion around the issues and a culture around the issues that helps to sustain the right kinds of interpretations of the clauses, and that there be public discussion on an ongoing basis on what was intended by a property rights clause is important before it's drafted, but also after it's drafted, in order to ensure that the courts continue to have instruction from the public, in a sense, on what was meant by that, and that they'll be held accountable if they interpret it in some way other than what was intended. At least in reputational terms, they're accountable, and judges are responsive to that kind of consideration to at least some extent.
What I'm thinking of is impeachment. The legislature has the power to impeach members of other branches if they behave in ways that are highly improper. It hasn't been used in a long time, but it does exist. And it is a real power of the legislative branch. We should remember that happens.
Okay, so you've reminded us of it. It's a very delicate matter, of course, because one does want to maintain judicial independence, but simultaneously to have some kind of check on judicial misinterpretations. And the subtler approach is, of course, to have that ongoing public discussion, but you've reminded us of other possibilities in an extreme scenario.
My question is property rights and the word property, and why we are focusing on property, because it has many definitions, and why we wouldn't focus on the start of a process and say just land rights, and then that would just give us that one section. We could build on that as we went along. I think that if we get into property rights, there's so many different meanings for property, but land is land, and that's really what I understand property rights to be.
Yeah, I think that's actually, well, what I was trying to capitalize is one of the issues with why property rights didn't make it into the charter. And I think you're absolutely right that there does need to be a more concise definition and kind of more of a consensus of what property rights means, because it is very broad and it can mean a lot of things, and even in the land context, it can mean a lot of different things when you're talking about protecting property rights. To protect it to different levels. So I think that's kind of the height of the issue there.
I'll just add that the Reed-Hillier Amendment, in referencing real property, is using the legal term in relation to land, and that avoids some of the questions about, is the clause referring to intellectual property? Is the clause referring to this new type of intangible property? There are possible challenges ahead if there's just a general property clause on things I don't even understand. They might, like virtual property. I mean, I can barely work my cell phone, and so I don't know what goes on in Second Life and these virtual worlds. There have been cases where property rights claims have been asserted to things in the virtual Second Life world and so forth. And what does a property rights clause have as implications vis-a-vis that? The focus on real property is a simple starting point that everyone knows what that means a little more clearly than something else.
I'm quite sympathetic. They gave me the mic, Tom, so I said I'm supposed to go next. I'm quite enjoying the discussion about the importance of language, and I pointed out to one of my colleagues at the table that there was a typo in the handout that he circulated, so clearly I'm a big fan of precision in language as well. But I wonder if you could help me, and my background is economics, with a definitional question that I've been wrestling with in the economics literature for a while. And it has to do with what economists refer to as categories of ownership. And I think the traditional understanding that's emerged maybe in the last 20 years is that there are 4 categories of ownership. There's what economists call open access, what Garrett Hardin called the commons, which is really a status of no ownership. There's common property, ownership by group. There's private property, and there's government property. And we've maintained this usage, I think, in the face of all kinds of problems, and I'm evolving toward a 3 ownership category definition, which says there's open access, there's non-ownership, there's government property, and then there's private property, some of which is owned by a group, some of which is owned by individuals, and that there's no meaningful distinction, and to some extent, maybe putting words in the late Eleanor Ostrom's mouth, that there really isn't any functional clear distinction between common property and private property, this individual versus group. And I just wonder from a legal point of view, if you could comment on that, or is there some legal idea that blows the economist's taxonomy into irrelevancy?
Well, my background's purposefully commerce and not economics. But I think, as you said, when we understand, for example, common property ownership, even if that means, the public enjoyment of a park, for example, or a library, that type of relationship is, based on cooperation and interrelations. However, I think, therefore, and then even when you consider, how would you set out rules for even everyone respect the park, no one pollute, that in itself is complicated enough. Whereas, what I think is that with private property rights at least, and when you think of the concept of you have the right to protect your own home, that in itself is specific enough, and then you can outline the ground rules of reasonable force when you feel legitimately threatened enough that you do need to protect your home. And it does bring up a good point in that the relationship that people do have between each other, the community, and the government. And that's why it shows that without even clearly identifying those three particular relationships, then the difficulty of specifically saying, well then what you as an individual, what do you have the right to protect? What can you do when you interact with a single person, when you interact with the community, and then when you're interacting with the state? But I do see that, and thank you for the economics lesson, because I clearly forgot.
If I can just add one further consideration, if you're looking at is there a difference between group property versus individual property or private property, I guess one of the key considerations would be, is there a right to exclude? And in fact, it might be that a group has property but has a right to exclude others, and then it actually resembles quite a bit individual property and may not be distinguishable in certain legal terms. But there will be other differences between these different kinds of property. I don't know if we have such a neat taxonomy of it as the economists do, it seems.
Just a quick comment on what John said a few minutes ago. In terms of the judiciary, I mentioned it yesterday, and it's all over the newspapers this weekend. Very, very dangerous, potentially dangerous thing happening right now in the form of Eli Lilly's investor state challenge under NAFTA, Chapter 11, where they basically have the chutzpah to say our courts don't know what they're doing when it comes to interpreting our Canadian law. But they, as an American company, do know what should be done. Now, if this goes anywhere, it will set a very dangerous precedent in terms of foreign investors. We Canadians don't even have access to this mechanism, telling our courts how to interpret our law. So that is a kind of check and balance, but I don't think one that we would be very happy with if it succeeds. And the other thing, I alluded to it, is, and Peter Hogg and others have written about it, is the book. Constant dialogue that's going on between Parliament and the Supreme Court. The Supreme Court does a charter case and says, well, this law is no good, but we'll give you a year to fix it up, and Parliament fixes it up. More often than not, there are some changes, and a viable law is the result. So there is a dialogue, there is a check and balance, and it happens all the time. I'm sure Dwight can mention all kinds of cases. But anyway, on to a couple other little points. One concern that's occurring to me with this bilateral idea, the bilateral amendment idea, and people said, should it include intellectual property or not? Well, I talked about that yesterday, but let's assume for the moment that it does, or that some people want it to. I don't think it's a good idea, but let's assume it goes forward. I have a real question, and maybe Dwight and his very smart students can look into this, as to whether or not that's even valid in terms of Section 91, 92, and all of that stuff, as to whether the provinces can do anything about ownership of intellectual property, because patents and copyright are clearly in Section 91 and not in Section 92, whereas property and civil rights are clearly in Section 92. And I know the Patent and Copyright Acts touch very little, and only to the extent absolutely necessary on questions of ownership. So I think that might be kind of threshold issue that needs to be looked into. And the other question I have, and I really don't know the answer to this, but I know it's a problem, because I've seen it in my own practice, is where, let's say I have a client in Ontario and a judge in another province, won't mention names, issues an injunction that I believe is clearly wrong, but I won't mention names. But that maybe affects my client in Ontario. Arguably does, and to be on the side of safety. I say yes, better pay attention to this injunction. Are we not facing a danger kind of balkanization where judges in one province issue injunctions that may or may not, maybe may, affect parties in another province, and we're going to end up with kind of patchwork, a very unworkable patchwork that would defeat a lot of the intentions of a confederation?
Okay, there are a few points there, and I'm not sure how to reply to all of them. But I'll just briefly say on the charter dialogue point that you've raised first, that of course Hogg has talked about that, but there have been some very strong critiques of whether there's really a dialogue that takes place. How much of a dialogue is it when the court says to Parliament, do this, and then Parliament does that? Grant Huscroft has written a lot on that. And in terms of referring to dialogue, I was referring to a broader societal conversation about rights and their meaning and about interpretation. But obviously there are some who have the view that Parliament's in that dialogue on a more basis. And just add a little note of skepticism on how much that works. But the question on can a bilateral amendment affect intellectual property is a very interesting one, whether there would be limits to the scope of what bilateral amendments could affect. Because the bilateral amendment would be something enacted by the provincial legislature and the federal parliament simultaneously, because that's the requirement for the bilateral amendment. It could be that it would affect intellectual property just in the one province, and that might be viable because the federal government is involved. So I'm not sure it raises a division of powers issue. If the province tried to just in its provincial constitution deal with IP, there might be more of a problem there. But there are some really interesting questions to face here, at least interesting for us. I know they're not interesting to everyone in the room. It's just an interesting question to go away and think on what the limits are there. In terms of both that and your worry about the balkanization in general, I guess my tendency would be to say that there are a lot of different legal frameworks in different provinces already. If there's stronger protection for property rights in some than others, that's a choice that some provinces could make, and hopefully over time it encourages other provinces to make that same choice as they see the good effects that come from that. But I don't see it as inherently a problem that there would be differences in the framework in the different provinces. We have the whole field of conflict of laws to deal with those kinds of questions. And within the Canadian Federation, it's, of course, complicated, but there are ways of dealing with these things. But there are other questions to go to, so those are some quick responses.
Yeah, I had two questions. First of all, at this meeting last year, and your team wasn't here last year, but we heard a whole lot about regulatory takings. That actually seems to me to be the real world issue. There isn't much expropriation of property in Canada without compensation. I would say it never happens, but I don't think it happens very often. But there is a whole lot of regulatory taking, devaluation of property through regulation. So would the Hilliard-Reid amendment have any bearing on regulatory takings, or would governments just continue on as they are now every day, devaluing property by propounding regulations? And if the amendment wouldn't have any bearing on regulatory takings, is it really worth investing when that seems to me to be the actual problem? Secondly, property, most people hear it, they think of ownership, but aren't there other forms of property that have been considered property? Like I'm thinking, for example, of leases. I believe a lease is considered a form of property. So with the property rights amendment, you might think you're protecting the rights of the landlord, but might you not also be creating new protection for the rights of tenants? And then what about easements? one way of understanding a lot of native rights is as easements. They probably would reject that term today because it doesn't have enough prestige, but you know, for example, the Treaty 8 right to hunt, fish, and trap off reserve could be considered as an easement on the ownership of the Crown. The provincial Crown now owns the land, but the inhabitants of various reserves have the right to hunt. So in protecting property rights, are you also protecting these subordinate forms like easements and leases? I'm assuming that entitlements clearly are not, but I guess I'll have to ask, is it clear in Canadian law that there's a distinction between entitlements so that you couldn't use an amendment like this for bootstrapping something like a pension entitlement or unemployment insurance claim, bootstrapping that up to the level of property? I don't know if there's an issue there or not being
I can speak to part of your second question. As you brought up, property itself has many different forms, many different definitions, and legally property is understood to be this bundle of rights, and what that includes, as you said, ownership, possession, as Dwight mentioned, the right to exclude. And you are right, it does bring up a lot of different things. For example, you reminded me of something like a trust relationship and how someone would have beneficial title over actual legal title. And therefore, what you've actually brought up is a very good point of showing how possibly, even with the good intention of protecting something so simple that we would think of private property rights, to therefore be used as something in a testamentary situation or in an easement situation. And which shows that when we think of something, so when we would want to protect the right to private property, does that just mean the right to exclude others from taking our property? Does that include, I have the right to possess this and I have the right to own this? And that does raise a very good point. And I mean, I would personally hope to not see it used for such things that would therefore stretch the meaning and, in my opinion, devalue the actual meaning, devalue the actual goal of why we would want to establish those rights in the first place.
Yeah, just on your point with tenants, I think it's kind of important to remember that the Charter protects against government infringements. So if you're considering someone who's just renting an apartment or a house from someone else, I'm not sure the Charter really applies because the government's not really involved in that transaction. So I guess maybe if it was a lease from the government, then it would be involved there. But I think private leases between private individuals, the Charter really wouldn't have too much of an application there. So I'm not sure if that addresses your concern.
The question points, though, to the real importance of getting the definition of property right in defining property rights, and that the way in which it's framed is going to be very important, and there needs to be some trust in the interpretation that the courts are going to give it over time, because there are questions that may not be easily answered in the text. So just to go to the question about could entitlements be a form of property, I don't know that that's really been litigated specifically in Canada because it hasn't arisen in a constitutional property context. There has been case law in the United States where there was an attempt to claim that Social Security benefits were a form of property protected then by the Takings Clause, and the US Supreme Court rejected that. But what would a Canadian court do in future with a living tree doctrine that is asked to define constitutional property? I don't want to bet on it entirely. So there needs to be careful drafting, careful guidance on what it's meant to mean so far as possible, but also ongoing engagement with the courts to try to preserve an appropriate meaning. Now, in terms of the first question, I know there are other questions, so I'll just speak to this really quickly. On the regulatory takings point, I guess I see the Reed Hillier amendment as referring to the loss of enjoyment of real property, and that might refer to a regulatory taking, but I guess there's an interpretation question there. As you've said, regulatory takings may be the big issue. Mark Milkey's done a good report for the Fraser Institute, Stealth Confiscation, on regulatory takings that I'd refer everyone to as a really excellent survey of a number of these contexts where it arises. And there's a delicate question of just how much do you put in a property rights clause and still get support for that while achieving the purposes that one's trying to achieve with it. And there's a delicate balance to be achieved there in any property rights clause. And the proposed amendment, I think, potentially catches some regulatory takings, only in the context of real property, but one might contemplate different language as well.
So my question is actually kind of related. Yesterday, Dwight, you mentioned the BC Motor Vehicles reference, and that makes me pretty skeptical about the usefulness of a clear drafting history. I know, not much else was very clear from that particular section of the charter than that they didn't want substantive due process, and yet 3 years later, boom, there it is. And I think Scott and Randy are about as clear as they can be about the language that they've used in their proposed amendment, but like I said, I'm skeptical that the courts will even bother looking at their intentions, or even if they included something like a statement of intent. So I kind of feel like all we're going to be left with is the actual text of that particular amendment. Yesterday during Howard's talk, he mentioned a professor that said, look, the thing to do when you look at a proposed law is you imagine the worst possible interpretation, the worst possible outcome, and then you can go to sleep that night knowing with complete certainty that that will definitely happen. And so I wonder if maybe you've had a chance to sort of speculate about the specific amendment that Scott and Randy have proposed, and whether you've considered the possible awful consequences. Like how could the courts misinterpret, because that's how I think they might do it, right? How could the courts misinterpret that badly? Do you think the language that Scott and Randy have chosen for the amendment is the right language to use? Maybe I could ask you to speculate about what you think might be the worst possible outcome of this particular kind of language. If there's ways to improve it.
Yeah, the language strikes me as very good in a lot of ways. If we're thinking what's the worst possible thing that could happen with this particular amendment, I mean, this is now at the risk of throwing in some unclear drafting history. And I guess my point on that would be to say that a clear, clean drafting history is probably a necessary condition for things, but not a sufficient condition for things. And if there's an unclean drafting history, it gives a court a tool later on to do something with that. So you avoid that so far as possible by keeping it as clean as possible. My one worry on this amendment would be, will a court interpret real property in this amendment to refer also to Aboriginal real property in some manner? Just what's the interaction of this language with Aboriginal property would be my biggest question about the particular language in the proposed amendment. And so I think that's something just to keep thinking on, and maybe even consider the possibility of an additional clause that says that it's specifically not intended to affect anything on Aboriginal property. And I'm not giving an exact phrasing there, but I would respectfully put that as a possibility for them to consider in the way that it goes forward. Because that would be, if we're going to that nightmare kind of scenario, is that the nightmare principle? So I guess that would be the one thing that I look at and say there's a possible risk.
It cites St. Catherine's Milling to say that Aboriginal title is personal use furniture, it's not property, right? I don't think you get away with that today.
I don't know if you get away with that today.
And sometimes I agree with our shaky, sometimes beliefs in support of our court, but as many of the interpretations of the Supreme Court of the Charter I do personally disagree with. They do look at the purpose behind the law. They do look at what the actual intent was. For example, in situations when looking at whether or not a particular law falls under federal or provincial power and jurisdiction, they do look behind the purpose of the law. And for example, gives provinces the power to sometimes tax banks. And even when the Supreme Court was looking at firearms reference the first time and unfortunately got it wrong, they still looked at what was the intent behind that, and that was public safety. And so sometimes, as much as it's hard for me to believe, just to give one note of confidence to our court, that as much as they might try to go around it, they still do look at it. And as Dwight said, it is a requirement, but not the only requirement alone.
That'll be the last question. So thank you very much, panel.